Welcome to This Constitution. My name is Savannah Eccles Johnston.
And I'm Matthew Brogdon.
And today we're going to talk about special counsels and political prosecutions. So first, I think people are very confused about what special counsels are. So let's just define why even bother with special counsels. What are they?
Yeah, the label gets applied to a bunch of different things. So actually, it's not even all one thing. But the way that we usually use it is whenever the Department of Justice employs a lawyer, a prosecutor, who's going to investigate and potentially prosecute wrongdoing inside the government. And normally that would be wrongdoing where there's some sort of conflict of interest. So maybe like a principal executive officer, or even someone answerable to or close to the president, or someone involved in a political campaign for the presidency especially. So you can see a theme here, some connection to the president. So there's some kind of reason to doubt that the ordinary prosecutorial process and folks who would be responsible for that in the Department of Justice could carry out whatever the investigation is.
Right. So this is kind of about public trust. Mm-hmm. So this starts actually with Grant. He's the first one to appoint, that we know of, a special counsel.
What, I didn't know that.
Except they're called a special prosecutor. Mm-hmm. Is what he calls them. And it's just to prove that you can do this investigation without political interference, basically without Grant looking bad. So you get this special prosecutor.
Was it an investigation of Grant?
No, it was of his administration.
Okay.
Yeah, so it was some scandal involved in, well, it's Grant. Okay. The Grant administration is just a litany of scandals. So then you get this.
Yeah, as all my Southern friends like to remind me.
Right, right. Then you you're a Southerner though.
I am, but okay. I'm also a Lincoln fanatic.
Oh, okay. So you're a traitor to the South.
Yes.
Okay, good for you. So then we fast forward and you get this with TR as well. Uh-huh. So special prosecutors, that's what they're called here, are completely normal. And it's not until you get to Nixon that they start to get controversial. Mm-hmm. So we first get to Nixon, and this is all about Watergate, and in particular about appointing a new attorney general. And the Senate makes it clear, basically, you're not going to get confirmed unless you agree to appoint a special prosecutor to investigate the Watergate scandal. And that's how we get Archibald Cox.
And there's no special statute at this point that, lays out how this should work. This is just something that the attorney general had been able to do under some broad authorization the law gave him to be able to hire lawyers to do special purpose things, right? The attorney general had for a long time had the ability to go out and find help when he didn't have the personnel internal. And so all the special prosecutor stuff right up through well into the 70s and through Watergate is all just on the basis of the general authority. Congress had never taken any special notice of this or provided anything in the law about it.
But I do think it's interesting that they make this kind of a tacit requirement for the attorney general to become attorney general.
Yeah, in the confirmation process, that is kind of fascinating. It's sort of like made this a condition of confirmation.
Right, and this is in a way stepping into the executive department's business, because the prosecution of crimes is an executive department job. So this is Congress showing a willingness to step in. And after the Watergate scandal, they'll step in a big way. But first, we got to get through Watergate. So Archibald Cox is the special prosecutor, the special
Cox
counsel.
Is like a law professor or something, right?
Yeah, he's outside the department.
Yeah. He's
just a civilian. And he subpoenas the White House tapes, the tapes from the Oval Office. Mm-hmm. And this is upheld by an appeals court. Of course, Nixon at first says he doesn't have the right to subpoena me. I'm his superior officer, so I don't have to obey this. The Court of Appeals upholds this. And then, in anger, Nixon turns around and tells his attorney general to fire Archibald Cox. Mm-hmm. And there's a name for this. The Saturday
Night Massacre.
Right.
The attorney general didn't want to do it.
Right, and he doesn't. He resigns, and so does his what is it called? The assistant attorney general?
I can't remember.
The second in charge.
There's so many uses of the terms under and assistant and deputy that I don't remember which one it is.
So number
but
two
whoever's
guy.
Second in line. Yep. And that leaves number 3.
Who is
Robert Bork.
Right.
Who is the Solicitor General of the United States. The Solicitor General answers to the Attorney General and does all represents the United States in front of the Supreme Court, mainly. And Bork actually wanted to resign too, funny enough.
Oh, I didn't know that.
He did. So Bork threatened to resign as well. And actually a number of folks in the Department of Justice and elsewhere in the executive branch told him, you can't do that, because if you resign too, there'll be no one left in the Department of Justice to run the place. And, as important as Watergate is, there were lots of other things going on in federal litigation. Like, we didn't stop prosecuting crimes. Right. The Supreme Court didn't quit doing the rest of its business just because the Watergate scandal was going on. So Bork actually sort of stuck around out of duty, but the only way for him to stick around was to agree to fire Cox. So this was the bitter pill he had to swallow.
So he does.
He does.
And he appoints a new special counsel who just continues what Cox was doing before.
Yeah, a guy named Leon Jaworski.
Right.
I know that because he was a Baylor grad.
Oh.
Yeah.
Something good out of the South. There you go. Lots of good things out of the South, Matthew included.
All right.
Okay, so he does the exact same thing that Archibald Cox does, and then also leaves. We eventually get 4 of these special counsels, by the way. And of course, when they do actually have to hand over the White House tapes, this will lead to, well, first, impeachment proceedings start because of the firing of Archibald Cox. So there's a huge public outcry. But then once they hand over the tapes, then Nixon will resign, and then there's no point in impeachment.
I also think it's kind of important that, and we talked about this, so listeners can go all the way back to, was it season 1, episode 1? And maybe episode 2, whenever we dealt with the executive privilege and we dealt with the Watergate tapes case in United States versus Nixon. I think it is interesting in that case, whenever the Supreme Court finally insisted that the president turn over the recordings of Oval Office conversations to the district court, it wasn't just a subpoena from the special prosecutor. It wound up being a subpoena from the district court. Mm-hmm. And when the Supreme Court held that the president had to turn these over, it was for the district judge to examine them in his chambers and decide which ones were relevant to the prosecution. So it is interesting to me that whenever the Supreme Court finally vindicated the kind of investigatory power here, they put most of their trust in the district judge that was overseeing the prosecution,
not in the special counsel.
Not the special prosecutor.
That's an important distinction. Yeah. Okay, so I know you have problems with special counsels, as what will follow, the kind that will follow. But for right now, what happens in the Nixon case is A-OK.
Well, there are challenges to it. I think it amounted to the argument. There is a certain problem here, okay, just to outline the general problem. The power to prosecute is definitely part of the executive power. Mm-hmm. So the prosecutorial power is the power to bring a charge against somebody and accuse them of having broken the law, and then bringing that into a court. And then, of course, the court, not the prosecutor, decides whether the law has, in fact, been broken and whether this person's guilty. So you've got both an executive function that's prosecutorial and a judicial function, which is finding guilt, right? Finding the facts and the law in the case. And so if you alienate that prosecutorial power from the president, you are definitely taking away a core executive function from the control of the president. So that's our fundamental problem here. So the question at hand is, are you taking away the prosecutorial function in a way that violates Article 2 of the Constitution, which of course says the executive power is vested in the president?
Right.
And with the special prosecutors that had been used prior to 1978 and the passage of the Ethics in Government Act, which we're going to talk about, and that includes the Watergate prosecutions, those largely comply with this rule because they are appointed by the Attorney General, who in turn is answerable to the president. And as the Saturday Night Massacre makes clear, if the president doesn't think the Attorney General is doing an adequate job of overseeing it, the president can fire the Attorney General.
Right.
Until he finds one that will remove it. Actually, this is very much like an old episode we've talked about before when Jackson fired the Secretary of the Treasury because the Treasury Secretary wouldn't remove the deposits from the bank. And he said, well, I'll just find myself another Treasury Secretary. So that is fine. And because of that chain of responsibility to the president. There's no prosecutorial power that's completely outside the president's supervision and control. And that's important, by the way, because the prosecutorial power is a very dangerous power. Mm-hmm. Even if you can't get a conviction, to bring an indictment and to pursue a prosecution against someone can ruin their life. So just by an executive, or a local district attorney can in fact just ruin people's lives bringing prosecutions. So you don't want an unaccountable pursuit of prosecutions because it can really do a lot of damage to people and destroy people's liberty. So the judgment that our Constitution makes is that, well, then that should be in the hands ultimately of a politically responsible individual.
Right. This is the argument that Scalia is going to make in a dissent in Morrison.
But before we get there, we got to talk about the ethics in government.
Right. So Congress is not viewing things the way you're viewing things here. So after the debacle of Watergate, especially the firing of Archibald Cox, they passed the Ethics in Government Act, which is 1978. And this is very interesting because it blurs a lot of lines of who is in control of what. So when there is a special case, Attorney General feels is a conflict of interest, someone in the president's orbit or the president himself needs to be investigated. The Attorney General can then turn to the judiciary and request 3 judges be appointed to a panel to then pick a special counsel, except here they're called an independent counsel. That person is then vested with the full authorities of the Justice Department, and they are only answerable and fireable by the Attorney General for cause. The judges cannot fire them. They can only hire them. Judges can't fire them.
But the judges can put an end to the investigation.
At the request of the Attorney General. So the Attorney General could request that the investigation be ended, but the real role that these guys are playing is just finding the individual who has to be outside the government. It's the Attorney General who fires and who creates the scope of the investigation and who can end the investigation. So it's the Attorney General who's doing this, though he has to continually report back to this 3-judge panel to tell them what's happening. So they set an expiration date on this law, though, and that's interesting. And it does expire in the 90s. Largely because of some controversies over Iran-Contra and I think it's Whitewater is the other one.
Yeah.
And then they re-up it again and it finally expires in 1999. So this is the independent counsel. This is not a special counsel. It's the independent counsel.
Yeah,
and it blurs a lot of lines.
With all the terminology flowing around, maybe a helpful way to distinguish between the special prosecutors we started out talking about, that the Department of Justice just created, and this new independent counsel under the Ethics in Government Act, and later what's just called the Independent Counsel Statute.
Right.
Is that word independent?
Yeah.
Special means they're just there for a special purpose, but still largely accountable through the same chain of responsibility as usual.
Right.
Using all the powers that any special counsel inside the Department of Justice would have. The independent part is quite interesting, and I thought it'd be interesting to read a little bit of what the statute says is that with respect to all matters in the independent counsel's prosecutorial jurisdiction, which we'll talk about, you mentioned the judges set that jurisdiction, it says that the independent counsel has, quote, full power and independent authority to exercise all investigative and prosecutorial functions and powers of the Department of Justice, the Attorney General, and any other officer or employee of the Department of Justice. So this is literally, if anyone in the Department of Justice, including the Attorney General, can do something, this independent counsel can also do it based on their own independent judgment.
Right.
So they don't have to consult anybody. Now, the jurisdiction part is interesting. You mentioned this. So what's meant by the scope and jurisdiction of the independent counsel's investigation? Do you have a sense of like what kinds of things could that include? I mean,
well, it's investigative power, but it's also the power to issue subpoenas and et cetera, and to hire other lawyers underneath you. It actually becomes more clear what that scope means when you get to the 1999 regulations.
Okay.
And that's part of the problem is what does the scope include here in this independent counsel?
So judges could say, we've identified that this is the special division of the federal courts, this 3-judge panel.
Right.
Can say, look, we think there's been some wrongdoing. It involves, the the chief of staff in the White House,
right,
or president's important advisors, or someone else close to the executive branch. And they set the scope, and they could say, let's just take the example of Watergate, if this had existed when Watergate did. Could have said, there was a break-in at the Watergate Hotel, the Democratic National Committee's headquarters. The special counsel is supposed to investigate that break-in and anything related to it. So that's your scope, that's your jurisdiction. So within that jurisdiction, with respect to that matter, the independent counsel could then exercise all the powers of the Department of Justice and the Attorney General to go pursue that investigation.
But this jurisdiction can change. It can be limited or it can be expanded.
Right. And by only by the special division, the courts that are overseeing this.
At the request of the Attorney General.
I thought the independent counsel can go back to the special division.
No, everyone understands it's only through the Attorney General. Maybe I'm wrong
because
on that.
Ken Starr went back. So whenever
he went back independent?
Yeah, so let's talk about the discrete controversies where this was used, right? So there are two. It's really important that there were two big episodes in the 80s and 90s where this became an issue. One involving Reagan.
And one Clinton.
And one involving Clinton. And by the time we got to the end of those two episodes, both Republicans and Democrats had decided, wow, politically unaccountable prosecutions are quite unpleasant and dangerous. Let's not do this anymore.
Although,
and they let it go.
There's also a Supreme Court decision right in the middle of this.
That upheld it.
That upholds it. So should we talk about Morrison real quick, or do you want to wait for that?
Yeah, let's talk about Morrison.
Okay, so let's talk about Morrison. So we've got Morrison v. Olson, which is a 7-1 decision for the court. Scalia is the only dissent. It's written by Rehnquist. Okay, and it's all about the appointment power. Does the independent counsel statute violate the appointment power? And their key answer is no, because the appointment power is about principal officers. And this independent counsel is clearly an inferior officer and not exercising any kind of principal officer authorities.
And this because the Constitution makes this distinction between whenever it talks about the president's appointment power, it says that the appointment of judges, ambassadors, and all other officers whose appointments are not otherwise provided for in the Constitution are to be nominated by the president and confirmed by the Senate.
Right.
Okay. So we get presidential nomination, Senate confirmation.
Right. There's only one way to hire.
And then there's this exception. Then you sort of get a period.
Right.
And then we get this other sentence that says, but Congress may vest the appointment of inferior officers in heads of departments, the president alone, or the courts of law.
Right.
So if somebody can fall in the category of an inferior officer, then Congress can provide for their appointment without the involvement of the Senate. And that's what Congress claims to have done with the independent counsel. They've identified this office and they've said that this special division of the federal courts can appoint this person to then use the prosecutorial power of the Department of Justice to pursue a prosecution in the executive branch.
And you've got big problems with this, and Scalia has big problems with this, because as it turns out, this inferior officer, this independent counsel, exercises all the powers of the Attorney General.
They are as powerful as the Attorney General, and more, actually, because there are things the Attorney General cannot directly do personally.
Right.
So this is actually combining, if anybody in the Department of Justice has a power to do a thing, from the Attorney General down to the lowliest, mailroom clerk.
Right.
This person can do that on their own judgment, as long as the special division of the federal courts has put it within their jurisdiction to do it.
Right. And second problem is, how do you fire this person? The Attorney General can be fired at will by the president, but the independent counsel has to be fired for cause. For
cause? What cause?
What that's a question they don't answer. What qualifies as cause? There's not a lot of
for a reason
cases that explain that.
Yeah. So, I mean, this has always been, this is an ongoing problem, not just with the special counsel, but as a sort of separation of powers problem generally. When Congress says you can't fire this person for any reason, it can only be for cause. Think, well, what are the legitimate causes? What if they're just making bad decisions?
Right. Well, they kind of spell this out just a tiny bit in Myers, a little bit, right? Dereliction of duty, negligence.
Right. The court speculates about what for cause removal would be. And typically it centers around something like inefficiency, neglect of duty. Those are just not doing something that they were told to do. They're not showing up for work.
Right.
They're incompetent.
They get sick.
Or some kind of malfeasance. They've actually done something wrong. They're doing something dishonest or wrong. But all of that excludes the case where someone is in good faith and technically competently doing something that you think is bad judgment.
Right.
Like they're making poor decisions, but doing so in good faith and not for corrupt reasons. And technically they're doing the job efficiently. Like all the paperwork's getting done and they're not, nothing's falling through the cracks. And that's actually contested. This is a huge debate in constitutional law. Why shouldn't incompetence include making bad decisions?
Especially when you are exercising the full authorities of a principal officer.
I mean, think about this, like
States.
with if the attorney general is just making boneheaded decisions and embarrassing the government or embroiling the country in unnecessary political controversy or violating people's rights and, out of poor judgment, you go, well, I don't care if it's in good faith and you think you're doing the right thing or that you're technically competent. You're making bad decisions and it's hurting the country and the government. So you're fired.
Right.
And that feels like for cause. Like if you came along and I was doing my job in a really dumb, boneheaded way and embarrassing the university, presumably somebody would say, I couldn't come back and say, yeah, but it was in good faith. I thought I was doing the right thing.
Right.
Like, no, you made dumb choices.
Right. So this is Scalia's big dissent.
Yeah.
That becomes actually quite powerful.
And because he says you can't call this an inferior officer.
Right.
And if it's not an inferior officer, and in fact this person is a principal officer, their job is too important and they have too much political discretion to classify them as an inferior officer, then they would need to be nominated by the president and confirmed by the Senate. And in that case, principal officers can be removed by the president for any reason.
Right. Because there's political accountability here with the president. Okay. What's so interesting about this episode, though, is that the courts uphold it and say, Congress, you can do this. It's Congress who created this statute who changes their mind and says, actually, this hasn't worked out well, both for Democrats and Republicans. We're going to let this law expire. Mm-hmm. So they don't re-up it. So in 1999, it expires.
It's worth pointing out, by the way, that I think Justice Kagan, before she went on the bench, had made comments to the effect that the court should have listened to Scalia and Morrison versus Olson. I mean, by the time we get through the 90s and into the 2000s, there's just sort of prominent, a lot of prominent con law figures sort of looking back on Scalia's lone dissent, the voice in the wilderness, and saying, he may have had a point there. Yeah. So
a
back
rare
to
time.
Right. So what happens? Why?
Right. So they let it expire. And it's 1999, but you still need some method for handling independent.
Oh, but we skipped over though.
Counsels.
What was the deal with Reagan and Clinton? What was so bad about what happened with those?
Oh, right. Okay. So first we get Iran-Contra, right? So there is a law prohibiting any aid to the Contras in Nicaragua, but it looks like they are funneling money, potentially unbeknownst to the president, to the Contras in Nicaragua. And so they're going to investigate this.
Because they have to find a source of funds.
Right.
Because otherwise they couldn't just take money out of the Treasury and give it to the Nicaraguans.
Right.
Because that would be that would be taking money out of the Treasury without an appropriation by Congress.
Right.
Violate spending power, which we talked about a few episodes back. Okay, so we're selling guns to the Iranians, taking the proceeds and supporting the Contras in Nicaragua.
Contrary to law.
If you don't, I mean, the most glorious thing about the Iran-Contra episode is that it gives birth to a Nintendo game, right? Isn't this where Contra? Yeah, Contra actually comes from like the South American setting, if anybody's ever wondered why.
I don't know what Contra is.
Oh my goodness. There was this great Nintendo game in the 80s.
Oh, okay.
Called Contra.
It was before my time.
No, it's good.
Okay, well, so I'm glad it did something positive.
It did something positive.
Contra.
Okay, so that got investigated.
Okay, and it leads to a bunch of prosecutions.
Yeah.
Okay, and then you flip the table, other side of the aisle, and you get Ken Starr. You get Whitewater. Mm-hmm. And what's great about this is going to lead to an impeachment based on just things discovered tangential
Right.
to the initial investigation, basically perjury, right? Saying you don't have an affair, you weren't having an affair.
And so this is where the jurisdictional part came in. They went, wow, an independent counsel can start out investigating, sketchy real estate deals. That was the Whitewater thing, where the Clintons involved in sketchy real estate stuff and some kind of fraud. And in the midst of that, in interviewing people, it turned out, wow, it sounds like, Bill Clinton's kind of a creepy dude. He's been doing sketchy stuff with his subordinates at work, especially young women. They discovered a history. Well, they didn't really discover it. Everybody knew Clinton's history of harassing women who worked for him. And that became part of the scope. So suddenly the jurisdiction you have this mission creep of the jurisdiction expanding outward until it just involved almost any wrongdoing that Bill Clinton had ever been guilty of.
Including just a White House intern who has nothing to do with the real estate situation, and him committing perjury and saying he hadn't had an affair with her. And it's on that basis that he is subject to an impeachment trial in the House and the Senate. And so this gives a really bad taste in the mouth.
The perjury and then the intimidation of people who would potentially bear witness against him. So,
Okay, so now both Democrats and Republicans say, actually, we don't like this. Turns out it could be weaponized against our guys. And how you control the scope of this investigation seems beyond any of our knowledge. It just spirals out of control. It goes on for years. So 1999, the law expires.
And why though? I mean, part of the question that comes out of that is like, why would it get out of hand? Why would it be less likely to get out of hand if it was a politically accountable prosecutor who was doing this? And I don't think it's just because it's the president would sort of protect himself. It's actually that, if you give someone this mandate, say you're totally independent, you have to go pursue, you sort of knight this person, you anoint them as sort of like knight errant to go root out wrongdoing in this case. The only sort of rationale operating is, go find wrongdoing and do something about it. And the problem with that when it involves the prosecutorial power, as you learn it, like if you read the Federalist Papers, you'll see this, is that you're just operating on that one set of criteria and you sort of forget prudence. But is it good for the public that we root out all the wrongdoing? Would it be best to leave some of the stones unturned? And the answer to that is yes. You don't actually want your attorney general in the state. You don't actually want your local DA to literally go out and try to turn over every stone and find all of the law breaking and wrongdoing in your community. In fact, the prosecutorial power requires making decisions about where to focus your resources. And part of that is just considering what's best for the public. That's a political consideration. So, what are the highest priorities for the public, and where does our investigation and attempt to root out wrongdoing need to stop? So that we're not misallocating resources or embroiling the public in controversy unnecessarily, or disrupting our, the government's appropriate operation and so forth. And those are all just political judgments that we depend on people to be prudential about. We depend on our attorney generals and our DAs to exercise good judgment about this. And the problem with the independent prosecutor is that they have no political mandate of any kind to consider those sorts of things. It's just, you're the knight errant. Go combat evil.
So what's interesting about this, though, is when the law expires, we move from independent counsel to special counsels under 1999 regulations promulgated by the Department of Justice.
So now we're in regulatory
territory.
So what's the difference between regulation and statute?
I mean, I thought you meant the independent counsel to the special counsel. It doesn't change that much, except that now the Attorney General is the only person authorized to go out and find a special counsel in cases of conflict of interest. They can be fired for cause by the Attorney General. They still possess the full powers of the Department of Justice, and the scope of the special counsel's investigation rests exclusively with the Attorney General. So really the only difference here is there's no panel of three judges involved. And instead of a statute, it's a regulation. So now we're in extra murky territory because we're talking about a regulation. And Morrison still holds except maybe it doesn't anymore because it was specifically about the Ethics in Government Act, which has expired.
And importantly, Morrison's never been used to support for another important decision on the Appointments Clause.
Right. So we don't actually have really a holding case on this.
We don't actually know if Morrison's any good.
Right.
It might be a zombie precedent. It's just sort of hanging out there, and the court may have just walked right past it.
Right. So we can see problems coming. So let's talk about the Mueller investigations.
Mm-hmm.
So this is about Russian interference into the 2016 election. That is what he is appointed to do. Jeff Sessions removes himself. It's his acting attorney general who, under the regulations, has the authority to do this. Rod Rosenstein.
Rod Rosenstein.
Right, Rosenstein, sorry, who appoints Mueller. And Mueller goes out, and in the course of his investigations into Paul Manafort, actually discovers a bunch of tax evasion and other stuff, which leads to prosecutions. And Manafort will say, this is totally outside your jurisdiction. The original scope of the investigation was just about the Russia trial, and now I'm on trial for tax evasion, among other things. And also this violates the appointment clause, et cetera, et cetera, et cetera. But the investigation into Manafort is upheld, and so is his eventual conviction. And it's based on the idea that, once again, a special counsel is not a principal officer, and therefore the attorney general, who has full control over this person, can. And
the other big change is the kind of authority they exercise. So we have that broad, unlimited scope for the independent counsel under the Ethics in Government Act that said anything the Department of Justice can do, you can do. Now the special counsel's rule, which is not based in statute, just based in a DOJ rule, gives them all the authority of a U.S. attorney.
Right.
And so a U.S. attorney is just is basically a federal prosecutor that's appointed for a given geographical area in the United States. Now, U.S. attorneys are incredibly powerful. They have fairly independent power to bring prosecutions and so forth, but they do have a specific role inside the Department of Justice. They are also normally considered principal officers. So usually this is somebody who's appointed with the advice and consent of the Senate.
Right.
So that's the controversial bit is, well, it's still pretty wide scope. On the other hand, you haven't actually given the person all the authority of the attorney general or all the authority of the Department of Justice. You've identified a particular kind of job and said, with respect to this case, you're going to behave like you're a U.S. attorney. Right. Subject to the attorney general's oversight.
And what's interesting about this as well is the findings from this report, and if the special counsel is removed, have to be reported to the House and Senate Judiciary Committee chairman and ranking member. So Congress is still involved in some way in this process, but there is no requirement that these findings be released to the public. Okay, now the big question is, who can fire this person? Under the regulations, it's the same. It's for cause. The Attorney General can fire for cause. And here's what they mean by that: misconduct, dereliction of duty, incapacity, conflict of interest, or a violation of department policies. So in the same way you might fire an attorney, U.S. attorney for violating
But this is one of those
policies.
Weird situations where when we usually think of a limitation on the removal power, we think of Congress reaching over and saying, you can't get rid of this executive officer unless they've done one of these awful things. And otherwise you have to tolerate their shenanigans. In this case, it's an internal Department of Justice regulation. That is, the Attorney General has created this rule and included it in the rules and policies and regulations of the Department of Justice. Now, rules and regulations can restrain the person who made them. You've given advance notice. I mean, basically what a regulation is, so maybe this is rolling back the curtain a little too far, but what a regulation is, when the Department of Justice says, we have these regulations, you're giving everybody notice that this is how we're going to operate in the future. It's not a law in the sense that like a statute passed by Congress is. So it's not irrevocable, but it's also not the kind of limit on executive power that a congressional limit on the removal power would be. So there's nothing really stopping the Department of Justice from saying, well, part of Justice Department policy is you don't make dumb decisions as,
right. So
special prosecutor.
At any time, because this is a product, a regulation from the Department of Justice. They could rip up these regulations at any time.
It's like a rule in Congress.
Right.
I mean, the best way to think of it is like, like the filibuster in Congress. Right. It's just a rule that the Senate made for itself. It can tear it up anytime it wants.
Right. So the Attorney General, in order to fire a special counsel, wouldn't even need to find cause. They could just rip up the regulation.
Yeah.
But the real question is, what happens if a president wants to fire a special counsel for political reasons? You're looking too closely into something. Can they? Well, this is according to this regulation. The answer is no, but it's not a law, and it's a regulation promulgated by a department that is inferior to you. Mm-hmm. So this is really murky water. Could a president just ignore these regulations or require that they be torn up and fire the person anyways? So we don't actually know. The courts haven't given us a decision on this, and presidents haven't really tried yet. But this special counsel thing kind of looms over us as a potential, not a constitutional crisis, but a constitutional question that needs to be answered and will probably be answered in a very politically toxic environment.
Yeah, and I think the crisis language that usually comes out in this, I'm less inclined to use, because I think the biggest crisis we would face is if the prosecutorial power is being abused or overused.
Right.
I don't think it's ever really a constitutional crisis if the prosecutorial power is being underutilized.
Right.
Now, it might be bad for the public interest. We might be letting wrongdoers get off the hook. But there's always a future opportunity to fix that, actually.
So you raised an interesting point before we started recording, which was, let's say you need special counsels, special investigators. They do a service, which is when there's a conflict of interest and you're looking to investigate something, you need some independence. We've seen the problems with the independent counsel. Now we have this regulatory special counsel, which has murky jurisdiction, who can fire them and when, which seems to maybe be a little better, but we've got a lot of unanswered questions. So the question is, if this person is not removed from presidential authority to fire except for cause, what then stops a president? What keeps a president in check? And your answer earlier was you have to impeach him first.
Well, I think the effective control of the president is always political control. I think there are very few legally enforceable limitations.
Right. So your preference for...
It's not that there are no legal limitations. I think the effective enforcement of limitations on the presidency is, in a sense, is pretty much political. That is removal from office,
right?
Congressional deprivation of funding. You just make life really hard for the president. The people can kick him out of office. Congress can kick him out of office. So I think we make a mistake whenever we think that we can use the ordinary legal process to control someone in a context where our Constitution establishes primarily political controls. Right. So we're trying to do a lot of stuff. I mean, I frankly think this is a difference between us and the founding generation. I think the founding generation expected the impeachment power to be a far more widely utilized sort of power. It's been extremely rare. And I think we've actually underutilized it. So I actually think our alarm has been, oh, no. Don't go around impeaching a bunch of people. That's the nuclear option. That's everybody thinks that's a constitutional crisis. I think, well, no, actually, it's precisely something like the impeachment power that was supposed to be the way to keep presidents responsible and rein them in whenever they got carried away or if it looked like they were doing bad things, high crimes and misdemeanors or what have you. And we've sort of flipped it around and we've said, no, what we should pursue first is prosecution, like a legal process, going and finding a crime and prosecuting it. And I think we've flipped that on its head.
Right. And that comes with inherent problems because the president is the chief prosecutor of the United States. He is in charge of enforcing the law. So then you have to do things like special counsels and make them independent. And then you've got appointments clause problems. You've got problems with Article 2.
And you embroil the courts in the political controversy. Right. I think this is one of the other really important issues here. Impeachment does not directly involve the courts.
Right.
Prosecution and investigation by subpoena and all the rest of that stuff through the ordinary criminal process puts the courts of law right at the center of the issue. And I do not think that the ordinary courts of law are well suited to deal with a sitting president or even principal executive officers. I think that's precisely why the framers, when they wrote the impeachment provision, said that impeachment could only extend to removal from office and exclusion from further office holding, but that it did not exclude additional prosecution or lawsuit based on what had been done. So there's an order of operations. You remove from office, then if prudent, you then pursue criminal prosecution or lawsuit by injured parties against that person to remedy the wrong. That's the order of operations the founding generation set up. It's the order of operations the constitutional text suggests. And trying to do it in the other order, start with the criminal prosecution. Then if that's successful, maybe we'll impeach. It's just got the whole thing backwards.
Right. So the special counsel problem can be solved by reinvesting in the political structure of the Constitution.
Actually, I think to the extent the special counsel mechanism is successful, it's where the president needs to use it to distance himself or the attorney general or other people from a particular prosecution. So I think the place where it's actually worked and been useful are the situations where a president has voluntarily employed it.
Like Grant or like TR.
Like Grant, like TR, or even like the, under Biden's presidency,
the Hur report.
Yeah. I think things like the Hur report, where you just need the legitimacy that comes from finding a sort of, usually somebody who's not politically associated with the Department of Justice. You go find some experienced prosecutor somewhere that's not politically tainted and everybody, sort of is trusted by all sides. And you get them involved to try to earn credibility for whatever the findings are in the investigation. That's actually where it's turned out to be useful. And that means it works well when it's useful to the president.
Right. So,
when you're trying to go after the president, I think it's a terrible mechanism.
So this points us to a theme that we've had this entire season about checks and balances, which is checks and balances work best when you lean into their political structure, their inherently political structure. And they get really murky, and we get lots of problems or potential problems when we ignore that structure in favor of a more legal structure and rely more on the courts.
Yeah.
So checks and balances are inherently political. Weaponize those political weapons. Allow them to be used in that context.
So use the framers' Constitution instead of fighting against it.
Yeah, it turns out it works just fine.
It works pretty well. Yeah, I like it.